subscribe SSPORT Productions to get the latest United Kingdom immigration updates and USA, Canada, Australian immigration updates.
Please subscribe to my channel to get the latest immigration updates.
Bringing your spouse to live with you in the UK. Are you married to a British citizen or a person with a permanent right of residence in the UK? Do you wish to make the UK your home and be permanently reunited with your loved one? If this is the case, you may wish to apply for what is known as a UK spouse visa. What will this visa allow you to do? A spouse visa will allow you to make the UK your home with your partner. Your application may be for entry clearance if you are currently outside the UK, or alternatively, depending on your current visa status in the UK, you may be able to make an application for leave to remain. This visa will give you the right to live in the UK and freely travel in and out of the country and even take up employment here. Under Appendix FM, entry clearance will be granted for an initial period of 30 months, and this will have to be subsequently extended for a further period of 2.5 years, before the initial period of leave expires. After 5 years you may be eligible for indefinite leave to remain and then subsequently British citizenship, subject to a few further requirements. The most important things to think about before making the application. 1. Accommodation. It is a requirement that you have adequate accommodation without recourse to public funds. While there is no concrete definition of what the Home Office will regard as adequate, the property must not be overcrowded by the UK standards and should usually be owned or exclusively occupied by yourselves. 2. Financial requirements. Your UK sponsor, in other words, your partner, will need to meet the financial requirements as specified by the immigration rules. The rules feature a minimum annual income threshold should they be relying on their employment salary. Another possibility is relying on any savings they have, for which there is also a minimum amount required. The stated purposes of these minimum thresholds are to ensure that people who are entering the UK will not end up relying on public benefits. The Home Office will require various supporting documents as evidence of meeting the financial requirements, and there are numerous ways to meet the requirement. 3. English language. In most cases, you will also need to meet an English language requirement either by taking a specified or having completed a degree taught in English. 4. Fees. The total fee for an application currently includes the Home Office application fee, the immigration health surcharge, and an extra fee for a priority service should you wish to expedite the application process. 5. Refusals. Despite the fact that a refusal of a spouse application gives you the right to appeal against the decision, there may be other consequences. On the most basic level, a refusal will result in a considerable loss of money by way of Home Office fees, and a loss of time. The appeal process mentioned above can take up to 12 months to be decided, and if you have made the application from abroad, you will not be allowed entry into the UK before the decision has been made. This will mean potentially extended periods of time away from your partner. UK spouse visas, top 10 reasons for refusals. Acquiring a spouse visa in the UK isn't as easy as one might expect. If you are after one, here are 10 reasons for UK spouse visa refusals. With all the changes being made to the immigration laws and all the added fees, getting a UK spouse visa seems harder than ever. Stories of families being separated for years have grown more common these days. Each heartbreaking tale only makes the idea of even trying for a visa seem that much harder. We want to help all families stay together and to make this entire process as easy and stress-free as possible. An important step in getting your spouse visa approved is to understand the reasons why it can be denied. Let's go through these reasons together. 1. Wrong online application form. This can seem simple to get right at first, but navigating through the multiple different forms available through the government websites can be daunting. Forms can look similar to others when you don't know what to look for, and it is because of this that we mention it first. You need to check and double-check to make certain the form you are filling in is exactly the correct one for your situation. 2. Incomplete forms. It can be easy to overlook one small box of information, but it is important that you fill in the forms completely before submitting them. The person who will either approve or deny your UK spouse visa will be going through these forms with a fine-toothed comb, and you should too. Check your forms multiple times. Even when you feel like you've checked them enough, it can never hurt to look over them one more time. It will save you a lot of trouble in the future. 3. Not enough proof of financial support. Only a person earning at least £18,600 a year can bring over a spouse to the UK, and the government will be checking to make sure that your family can uphold that kind of financial support. This is a sum that a lot of British people are finding hard to achieve, but the fact remains that it is still the rule. The sponsor of the applicant will need to provide them with substantial proof showing their earnings. 4. Wrong type of online bank statements. Going together with the necessary financial proof, one way of doing this is by showing bank statements. However, you need to use original bank statements to get your UK spouse visa approved. Printouts from the internet will not be enough in this case. 5. Criminal history. Individuals with a history of criminal activity will find it much more difficult to get an approval than those without. It can often depend on the nature of the crime, as well as how much time has passed since that crime took place. Under the Rehabilitation of Offenders Act, it can be possible that a crime committed a long time ago will be ignored. However, this is all very dependent on the individual and the crime. You should be aware that anyone applying for a UK spouse visa who has a criminal record will be under more scrutiny than others. 6. Previous refusals. It can seem unfair, but unfortunately, the entire process can be a bit unfair sometimes. If you've previously applied for a visa and were refused, the chances of your next attempt being refused will be even higher. Previous refusals are not an immediate reason for a person's application to be refused, but it will make the reviewer look over everything even more finely. They'll be particularly interested in looking for any discrepancies in the information you've provided, as well as looking for whatever it was that made them refuse you in the previous cases. 7. False documents. Supplying information that is not correct will not be accepted. Everything you write down in the application will be checked and double-checked by the person reviewing your case. There will be phone calls and searches to find out more about you and your loved one before the U.K. spouse visa will ever be approved. If there is falsified information on those documents, they'll find out about it. Make certain to always write down the correct information to the best of your ability to keep this from happening. It can lead to a lot more trouble for you if misinformation is given. 8. Not qualified. You have to make certain to read up on the necessary qualifications and information about the visa before ever applying for it. If you don't know everything there is to know about the visa, chances are that you'll overlook something that might lead to your visa being refused. Be certain to take the time to learn about the rules and the process. It will help you stay informed about everything you can expect before jumping into the deep end. 9. Forgotten documents. When you apply for a UK spouse visa, you'll need to provide the appropriate persons with a number of different documents. If you forget one of them, it could lead to your application being refused. A general idea of the needed documents include but are not necessarily limited to: a completely filled out visa application, a current passport, bank statements from at least the last 3 months, remember, not just printouts, proof of identity, results from a tuberculosis test, proof of education and any degrees a person might hold, recent photographs, proof of residence, marriage certificates. Certain documents may be added to an overall list depending on the individuals involved and any outlying circumstances in their situation. 10. Forgetting English translation certification. Any persons needing to translate the English application into a different language will need to provide information about that translation. To keep it as smooth as possible, you should choose a professional translator. You'll have to give the name, address and other contact information about the person who did the translation, as well as a full signature from that translator verifying that the translation is correct. All of this should be done on a proper certificate form. Final thoughts on UK spouse visas. All of this may make it seem nearly impossible to get your UK spouse visa approved, but don't despair. Keeping yourself informed is one of the best ways to make sure you can get through this process as swiftly as possible. You don't have to do any of this alone. You can seek out immigration advice from professionals who want to help you through this process and make your life easier. UK spouse visa applications, further leave to remain, marriage to a settled person, and further leave to remain, family and private life. It can be a significant upsetting activity to apply for a visa. The candidate must know which form to fill, how to fill it, and what supporting records are required. So if one is applying for UK spouse visa, then you must prove few things in order to get your visa application successful. This means that you have to meet certain requirements. Now you can apply for UK spouse visa from outside UK and in the UK both. In the event that you are applying in the UK, then you can apply on the web or you can apply by post or face-to-face. Now as spouse you meet certain requirements to get a grant for leave to remain in UK. After your stay for the time allowed in UK, if you want to extend your stay in UK, then you can apply 2 forms. Which form to fill depends on which category you are applying for. You can apply as partner, parent, or just under private life. Depending on this ability of proving these requirements, one can fill in either of the 2 forms. One is Form FLR-M. This form is for those who are married to or a dependent child of a person settled in UK and can meet the requirements, and 2 is Form FLR-FP, is for those who are a partner, parent, or dependent child or based on the private life in UK. Now let us see what these 2 forms are. Spouse visa application under FLR-M. If you are living in UK on UK spouse visa after your stay in UK for the time granted, you can apply for extension. So, FLR-M is an application which you can use to apply to extend your existing stay in the UK, ILR, and get a biometric resident permit. You can use this form if you are a partner or dependent child of someone who is settled in UK. So, for those who are applying as partner, must be married to a person that is already settled in the UK, under the Appendix FM. But important thing to note here is that just being married to an English citizen is not enough to get this permission. In order to get your spouse visa to stay in UK, you will have to meet all the requirements. This includes your status in the UK, and you also have to meet the financial requirement. If you meet the requirement, then you use this form, and after successful application you will get a 2.5 year in the 5-year partner route. You can use this form if applying in family life category under following condition for further leave to remain in UK. As the partner of a person present and settled in the UK, 2-year route. As the partner of a person present and settled in the UK, 5-year route. As the partner of a person with refugee leave or a person with humanitarian protection, 5-year route. As the dependent child of a person who has, or is at the same time applying for, limited leave as the partner of a person present and settled in the UK, 2 or 5-year route, other than under the points-based system or UK ancestry. Spouse visa application under FLR-FP. FLR-FP application stands for Further Leave to Remain, Family and Private Life. This application can be used to apply for first grant of leave to remain in UK or for extension of for existing leave to remain in UK to extend their leave to remain in UK in these 2 categories. Family life. Under this category, one gets the right to apply as a partner or parent of a child. This means you can apply for family life as a partner of someone settled in UK or family life as a parent of child. The child can be British or non-British also. If the child is non-British, then the child must have lived in UK for more than 7 years or more. One should apply this when parents are divorced and the child lives with one of the foreign spouses. Private life. private life applying has the same form, but this form is for those people who have spent years in the UK and now want to legalize their stay. If they get the approval, then they get a 2.5-year visa in a 10-year route. After 10 years, you can apply to secure your permanent residency. Indefinite leave to remain for spouses, complete procedure. Non-EU nationals who can reveal continuous residence for a duration of 5 years within the UK as spouse can be eligible to use for indefinite leave to remain. It need to be mentioned that indefinite leave to stay is often additionally known as settlement. The key benefit of obtaining indefinite leave to remain is that you may no longer be under immigration control and you'll have permission to reside inside the United Kingdom for an unrestricted period. You will also be entitled to get entry to the NHS and you may have access to public funds. Further, after attaining indefinite leave to remain for a year, you may then proceed for British citizenship. How to apply for indefinite leave to remain as spouse. You may be eligible to apply for indefinite leave to remain as a spouse if you meet the requirements listed under paragraph 287 of the immigration rules. In order to apply for indefinite leave to remain as a spouse, applicants must have continuously resided in the United Kingdom with valid leave for a minimum period of 5 years. Similarly to the initial spouse visa and extension application, applicants are still required to show that their relationship with their spouse is genuine and subsisting. In addition to the relationship requirement, applicants must meet the financial £18,600 accommodation and English language requirement. Whilst applicants are free to travel outside the United Kingdom on their spouse leave, it should be noted that they should not have excessive absences from the United Kingdom. There are some exceptions to the absences requirement, and in some circumstances, representations can be prepared and submitted to the Home Office to explain the mitigating circumstances behind excessive absences from the United Kingdom. Ultimately, the caseworkers have discretion available to them whereby they can choose to grant an application where they believe there were valid reasons for the absences. The application itself is submitted by the usual postal method and a decision is usually made within a 6-month period. However, we have noted that well-prepared applications usually receive a decision within 3 months from the submission date. Team of solicitors prepare indefinite leave to remain applications at a high standard and have an impressive success rate. There is the same-day premium visa service option available for an additional fee. The premium visa service allows applicants to take their completed application to a Home Office center where their application is reviewed and a decision is made on the same day. However, in some circumstances, the Home Office can delay a decision. This is normally when there are complex issues involved in the application. It is recommended that legal advice is obtained prior to booking a premium visa service appointment. English language and life in the UK test for your indefinite leave to remain application. One of the key requirements for an indefinite leave to remain application is showing that you meet the English language requirement and, more importantly, you have sufficient knowledge about life in the UK. These requirements apply to everyone aged from 18 to 64. In order to meet the English language requirement, applicants are required to pass an English speaking and listening qualification at a minimum level of B1 CEF or higher. Applicants must also sit and pass a Life in the UK test. The purpose of the Life in the UK is for applicants to show they are accustomed to and have integrated to life in the United Kingdom. It is important for applicants to book this test in advance of the expiry of their visa, as there are limited time slots available at the test centers. Applying for British citizenship after acquiring indefinite leave to remain. Applicants who have successfully acquired indefinite leave to remain can apply for British citizenship after 12 months from the date of their indefinite leave to remain. For example, if you were granted indefinite leave to remain on the 2nd of July 2018, you may be eligible to apply for British citizenship on the 2nd of July 2019. Can indefinite leave to remain be revoked? Applicants who have successfully acquired indefinite leave to remain must be cautious of the conditions of their leave. It is not uncommon for the Home Office to revoke indefinite leave to remain where an applicant's circumstances change. An example of a scenario where indefinite leave to remain will be revoked is where an applicant is no longer permanently resident in the United Kingdom and has been absent from the United Kingdom for a period of more than 2 years. However, the 2-year absence rule does not apply to British overseas citizens and British subjects. In addition to this, indefinite leave to remain may also be revoked when there are issues regarding public safety, national security. If you have been in trouble with the police, it is recommended that legal advice is obtained immediately to ensure that you are well prepared for lengthy litigation with the Home Office. The Home Office will also revoke indefinite leave to remain where they believe it is obtained fraudulently. Using legal representation to submit a successful indefinite leave to remain application. Legal representatives, such as your specialist immigration and visa law firm, are qualified to advise you on immigration law and your immigration matter. You can instruct one of your immigration and visa legal representatives to successfully assist you with an indefinite leave to remain application. Your solicitors and barristers will help you comply with the Home Office's requirements and meet the immigration rules. Caseworkers at the Home Office are trained to reject indefinite leave to remain applications which are improperly prepared, for example by failing to provide the correct supporting evidence. In order to ensure your indefinite leave to remain application succeeds, your solicitors and barristers will ensure all specified documents must be provided. The UK immigration rules are complex and a legal representative can help ensure that your application meets the immigration rules. Caseworkers at the Home Office are taught to reject ILR applications which might be improperly prepared, for example by way of failing to provide the ideal supporting evidence. For you to make sure your indefinite leave to remain application succeeds, a team of solicitors and barristers will ensure all special files must be provided. The United Kingdom immigration rules are complicated and an experienced consultant can help make sure that your ILR application meets the immigration rules.